If you became a U.S. citizen through naturalization and recently found yourself lying awake at night wondering, can they take this away from me? You are not alone. You see the headlines, you watch the enforcement footage, you hear words like crackdown, deportation, immigration overhaul, and suddenly something that once felt permanent starts to feel fragile. You worked for this. You studied for the civics test, passed the interview, stood in that courtroom, and took the oath. That moment was supposed to mean safety, finality, protection. So when immigration policy dominates the news in February 2026, it is completely natural to ask whether anything has changed about your citizenship, whether naturalized citizenship is truly secure, and whether enforcement policies could somehow reach you. Today, we are separating fear from fact, headlines from law, and speculation from constitutional reality. Because there is a massive difference between a louder enforcement environment and an actual legal threat to your citizenship. And understanding that difference changes everything. Hi, I'm Sophia, and welcome to Green Card Navigator. Here we break down immigration policy clearly, calmly, and factually, especially during moments like this, when anxiety spreads faster than accurate information. In this video, we are walking step by step through what immigration policy in February 2026 actually means for naturalized citizens, what the Constitution guarantees, what denaturalization really is, and what it is not, and the practical steps you should or should not take right now. This is not about politics. It is about law, rights, and clarity. By the end of this, you will know exactly where you stand, what is protected, and what you can confidently stop worrying about. Let's begin with the foundation, because once you understand this clearly, much of the fear starts to fall away. Under the United States Constitution, citizenship once lawfully granted is permanent. That is not a political opinion, and it does not depend on who is president. It is constitutional law, backed by decades of Supreme Court precedent. If you completed the naturalization process properly, met the residency requirements, passed your English and civics exams, disclosed the required information, and took the oath of allegiance, you are a United States citizen with the same constitutional protections as someone born in this country. Your citizenship is not a visa, not a green card, not conditional status. It does not renew, it does not expire, and it cannot be taken away simply because enforcement becomes more aggressive or political leadership changes priorities. Executive orders cannot override constitutional protections. Enforcement strategies cannot rewrite the 14th Amendment. Congress cannot pass a simple law stripping lawfully naturalized citizens of their status. Citizenship, once properly granted, is one of the strongest legal statuses in American law. Many naturalized citizens, however, subconsciously carry over the anxiety they felt as permanent residents. As a green card holder, there were conditions, risks, renewal requirements, and travel limitations. Citizenship is different. It is final. It is constitutional, not administrative. If this kind of clear, fact-based explanation is helpful to you, make sure you are subscribed to Green Card Navigator so you do not have to rely on rumors or social media threads the next time immigration dominates the headlines. Accurate information is one of the strongest forms of protection you have. Now let's address the one word that often causes panic: denaturalization. This is the narrow legal exception people hear about without fully understanding. Denaturalization is a formal legal process that can only happen in federal court and only under very specific circumstances. The government must prove that someone obtained citizenship through fraud, willful misrepresentation, or concealment of a material fact during the naturalization process. This is not about political disagreements, party affiliation, or criticizing the government. It is about whether the original naturalization was legally valid. To meet that standard, prosecutors would need evidence that someone deliberately lied on the N-400 application, hid serious criminal history, used a false identity, concealed involvement in persecution or terrorism, or omitted information that was legally material to the approval decision. Even then, it is not automatic. The government must file a civil lawsuit. The individual has the right to legal representation. There is evidence, discovery, and a judge. The burden of proof is high. Historically, denaturalization cases are rare, time-consuming, and expensive. They are individualized court proceedings that often take years, not mass administrative actions carried out in bulk. There has been no new law lowering the burden of proof, no Supreme Court ruling weakening constitutional protections for naturalized citizens, and no executive shortcut allowing large-scale citizenship revocation. When you hear the phrase revoking citizenship, understand that in reality it refers to a narrow, fraud-based court process, not a political tool that can be used against law-abiding naturalized Americans. So why does 2026 feel different? The answer is enforcement visibility. Immigration enforcement operations are more public. ICE activity is more visible. Detention policies are stricter. Border enforcement has intensified. Deportation efforts are focused on individuals who are undocumented or who have final removal orders. That visibility changes how communities feel, even when it does not change the legal reality for citizens. When workplace raids appear in the news and removal operations trend on social media, it can create the impression that the entire immigration system is unstable. But enforcement actions target immigration status violations. Naturalized citizens do not have immigration status. You have citizenship. You are not subject to deportation proceedings. You do not need to renew anything. Your legal relationship with the United States is fundamentally different from someone who is undocumented, or even someone who is a permanent resident. Tone is not law. Visibility is not a constitutional amendment. Intensity does not rewrite citizenship protections. There are also several myths circulating right now. One is that mass denaturalization is coming. There is no legal mechanism for stripping citizenship from large numbers of naturalized Americans through administrative action. Another claim is that certain nationalities or religious groups are being targeted for citizenship revocation. Denaturalization must be based on fraud or material misrepresentation, not race, religion, ethnicity, or political belief. Targeting citizenship revocation based on those characteristics would be unconstitutional and immediately challenged in federal court. A third myth is that naturalized citizens must take urgent action to protect their citizenship by filing special paperwork or paying private services. None of that is necessary. Your citizenship is protected by the Constitution, not by additional filings or paid programs. Be cautious of fear-based businesses that emerge during times of uncertainty. There are practical steps you can take, not because your citizenship is in danger, but because organization brings peace of mind. Keep your naturalization certificate in a secure location. Make physical copies and, if possible, secure digital scans. This is not because someone is about to question your citizenship at random, but because having immediate access to proof reduces stress when applying for a passport, sponsoring a family member, or replacing documents. Review your rights as a citizen. You can vote, you can hold a U.S. passport, you can petition for family members. You cannot be deported. These rights are enforceable. If you have family members who are permanent residents and eligible for naturalization, this may be a meaningful time to encourage them to apply. Permanent residence is strong, but it is not the same as citizenship, and naturalization provides a level of finality that becomes especially valuable in a high enforcement climate. If you are wondering whether you need an immigration attorney right now, most naturalized citizens with straightforward histories do not. If you obtained citizenship lawfully, disclosed required information honestly, and have not been contacted regarding fraud or misrepresentation, there is no preventive filing you need to make. Citizenship does not require maintenance or renewal. However, if you are sponsoring a relative with complex issues such as prior overstays, removal orders, or criminal history, or if you receive official communication questioning past representations, that is when consulting a licensed immigration attorney makes sense. Make sure the person you consult is actually licensed to practice law. Be cautious of consultants or notarios presenting themselves as attorneys. Real legal guidance should reduce anxiety, not exploit it. There is also an emotional layer that deserves acknowledgement. Many naturalized citizens carry years of immigration-related stress. You may remember checking case statuses repeatedly, worrying about paperwork, fearing that a small mistake could derail everything. That psychological imprint does not disappear overnight just because you received a certificate of naturalization. So when enforcement headlines surge, even if your logical mind understands that your citizenship is secure, your nervous system may still react. That reaction is human, but legally, your position has changed. You are no longer in a provisional category. You are a United States citizen. As we look at the bigger picture in February 2026, it is important to separate political climate from constitutional structure. Political climate can shift quickly. Enforcement priorities can intensify. Media coverage can amplify every action. But constitutional structure moves slowly and with high barriers to change. Citizenship is anchored in the 14th Amendment and reinforced by decades of Supreme Court precedent. It does not change with each election cycle. Immigration enforcement in 2026 is visible and active. Deportations of undocumented individuals are occurring. Policy debates around asylum, work visas, and family-based immigration continue. None of those developments alter the permanence of lawfully obtained naturalized citizenship. If you applied truthfully, met eligibility requirements, and took the oath, your citizenship is secure under the Constitution. That is not optimism, it is legal fact. The path forward is not panic. It is awareness. Stay informed through reliable sources. Keep your documents organized. Encourage eligible family members to naturalize. Seek professional advice when situations are complex. Most importantly, allow yourself to live in the stability you earned. You have the right to vote, the right to hold a U.S. passport, the right to petition for family members, and the right to live here without fear of deportation. Those are enforceable constitutional protections. If this explanation helped you better understand what naturalized citizenship protects and what it does not, make sure you subscribe to Green Card Navigator. We are committed to fact-based immigration guidance that cuts through misinformation and focuses on what the law actually says. Share this with someone who might be worried but has not asked these questions out loud. And let us know in the comments what topics you would like us to cover next. Accurate information is protection, and that is exactly what this space is here to provide.